Yes, they've withdrawn that.
Okay.
And then the defense does not want self-defense instructions, but the state believes we're entitled to them since Mr. Davis claims self-defense in at least one of his statements.
Been raised by defense. It's something that they disagree with my ruling with pretty strenuously, and in the record there is, that statement by Detective Kading in that 2008 interview that this will never be used or this will never be heard, which was the basis for that voluntariness. I still think that wasn't the correct framework, but I think giving it ultimately to the jury is maybe a way to hedge our bets.
Weight it wants to give to the statements, that's fine too, but it is axiomatic that we do not have to corroborate a confession, and the law supports that.
You just stated that in order to get into the statement, you have to show that a crime has been committed, and the state did that because we have a body. That's literally the corpus. So a corpus is beyond approved, right?
Correct.
So Brookie West is totally different because Brookie West, there's no body. And so how do we know that it's a crime? Those are all the issues. Here we have a body. We've always had a body.
I know, but I don't think the instruction should be given because it was not an issue in this trial.
Corroboration.
You admitted the confessions. This would be an issue to keep the confessions out of the jury's hearing. But here, they got to hear all the confessions. So now we're infringing upon the right of counsel to argue their case in front of the jury and the right of the jury to make the decision, the duty of the jury to make their decision beyond a reasonable doubt. This instruction should not be given at all.
All right, so
I'm sorry.
You might want to just listen for a second, Mr. Paul. Okay, so the state's instruction, I believe, is in reading through and reconciling it with Septon versus State, as well as the reiteration in the Brookie West case, is a correct statement of the law. However, I think the arguments of defense and everyone has been that these statements are not to be believed. And so I think the if believed language borrowed from Gaxiola adds that component in. So what I'm going to do on this instruction is say where independent evidence establishes the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime.
Your Honor, so you're going off of the state's?
Correct.
Can you do it a little bit slower, please?
Absolutely. I'm going to send you guys a copy of everything, but where independent evidence establishes that the victim's death was caused by the criminal agency of another, and just paraphrasing, that is directly from West, a defendant's own statements, if believed, admitting the crime, need not be further corroborated by evidence connecting the defendant to that crime.
Are you going to add any of this defense proposed the defense proposed instruction?
So, the defense. Well, the defense proposed instruction says there needs to be slight corroborating evidence independent of any confession or admission, but that ultimately goes to the crime, to whether corpus is established. So the first paragraph is, or the first line is literally saying where corpus is established, but explaining what corpus is. So I don't think that there's any way, given the court's ruling, to include that a slight or prima facie showing permitting the reasonable inference that a crime was committed is sufficient, because that would be impeding essentially on the corpus determination, which we've all agreed in this case is established. There need not be. And additionally, the final line of what this defense has proposed does say there need not be independent support for each fact contained in the confession or admissions in order for the crime to be proven independently of defendant's confession or admissions. Is that something that you're seeking to have added, Ms. Panduct?
I moved to have the entire
okay.
instruction, and I would ask that any part of it still be given because I believe it is more informative and less confusing and misleading than the instruction that the state is proposing.
Okay. Any objection to the final line being added?
Yeah, I think it actually confuses the instruction as currently given.
Will be given. And then the final issue we have before we dive into just going through the instructions one by one would be the argument regarding self-defense. My initial reaction when you said this was self-defense is ultimately a defense. And so all of the instructions in Runyon go to the amount, or whether they're given, goes to the amount of evidence that a defendant presents and that a defendant argues. And I've never seen it given over the objection of the defendant.
Well, while I appreciate that, and I know Mr. Shaft has made a number of arguments to this jury, there is evidence of self-defense present, and the state is required to rebut that evidence beyond a reasonable doubt. Part of that evidence of self-defense involves him being the initial aggressor. So the jury has to know that while he may have asserted self-defense, let's say they only believe the book version, right? Or they reject everything else and only believe the book version. The book version is it was committed in self-defense. Right, it's sort of like the mere presence instruction that's in here. The 2009 statement is more, I'm merely present at this particular event. Both the 2017 and the 2019 book is like Tupac shooting at us, so someone from the back seat started busting. Okay, well, Tupac would have been allowed to shoot at you. I know that there isn't a lot of evidence to support that. But the jury needs to be instructed on what the elements of self-defense are, because one of defendant's defenses, not Mr. Shams, but defendant himself, in his own statements, his defense is self-defense. And so we're entitled to have a proper instruction of that isn't self-defense. Even if you believe what he says only in the book, that is not self-defense.
But in order for you to tie Mr. Davis into this event whatsoever, there has to be an overarching plan already at the time that the self-defense came in.
I agree. That's why legally, right? Legally, he's wrong, right? He doesn't know the law of self-defense, but a lot of defendants give confessions and statements and go, hey, it was in self-defense when they ran up on somebody with a gun and that guy pulled the gun out and shot at them and hit the woman behind them, right? I mean, that case we have right now. That defendant says, oh, I committed the crime in self-defense. Well, as a matter of law, you ran up with a gun on somebody, you don't get to claim self-defense. So the jury needs to be instructed on what the law of self-defense is, because there is some evidence of self-defense in the case. Whether the defense is going with that defense or not, whether Mr. Shaft argues it was in self-defense or not, isn't relevant. The law is, if there's evidence of self-defense present, the state must disprove it beyond a reasonable doubt. And since the defendant has asserted in at least two statements that the car was acting in self-defense, the jury's entitled to know what the law of self-defense is.
Remind me, does he actually say
He says the word self-defense.
self-defense, or does he say that, we thought he was going to get to popping or something like that?
No, at one point he says...
I'm confusing it with a different statement.
At one point he says, and I can't remember if it's in 2017, I think it's in the 2017 audio recordings, where he tells Mr. Diaz, yeah, it was in self-defense. He actually uses the word. I can word search the various statements, but when I heard that, that's what caused me to go, wait a second, we need to put an instruction in here because...
Okay, so I guess I see where you're coming from now. Defense, what's your position regarding this?
...2017, where Mr. Diaz is, so you're saying it's in self-defense is what really happened, and Davis says, yeah.
So Mr. Diaz says that.
Well, he uses the word self-defense, but I mean the description of what Mr. Davis is saying is, hey man, Tupac pulled out a gun and started shooting at us, and so we had to shoot back. And so Diaz is saying, so you're now saying it's in self-defense, and the defendant says, yeah.
Any all right, I'll give you the run-in instructions. So we've gone through voluntariness of statement. That was granted. We're going to give instructions on that. Over state's objection, we've gone through corpus delicti. That was given over defense objection, and then self-defense is sort of, you're asking to take this on, and we're not sure why, but you want it, so we're going to give it to you.
Short one.
All right, so the
Okay,
Bowman
we wanted the
instruction
short
needs
one
to be
again.
given, which states, during deliberations, other than deliberating with each other in the deliberation room, jurors are not to communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. Read, watch, or listen to any news or media accounts or commentary on the case. Do any research, such as consulting dictionaries, using the internet, or using reference materials. Make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on their own. Any objection to that wording of the Bowman instruction? I think
Which
that's
instruction is this?
it's the instruction from
Which number?
objection to it. Ms. Panic, any objection to the form of verdict?
Mr. Samt had requested that not guilty be listed first. I told Mr. Drachman I did not agree.
We object.
In general, in most cases, I have no objection to doing it that way, but because of the way that the step-down instruction works, it makes sense in homicides to have it in this order. And so I understand the objection, and I understand why it's been upheld multiple times going in the descending order. Essentially, it converts the step-down instruction to a step-up instruction, and so that's generally why I don't do it in these cases. But